Howdy, my name's Brian Foley. I'm a criminal defense lawyer in Conroe, Texas. I help folks who've been accused of a crime in the Woodlands, Conroe, Houston, and that general area. Today, we're going to be talking about Kyle Rittenhouse, the trial that's going on right now, and some headlines that we saw in the news. So CNN's headline is, as trial approaches, judge will allow men Kyle Rittenhouse shot to be called rioters, but won't let them be called victims. NBC News says men shot by Rittenhouse can't be called victims during trial, but rioters, looters are okay. Basically, there's this issue. The judge is not allowing the prosecution to call the people who were shot victims, and they are allowing the defense for Kyle Rittenhouse to call them rioters, looters, things like that. So does this mean the judge is a terrible person? He's biased against the state. He's a Republican appointee who's just evil and should be taken off the bench? Probably not. So let me tell you my experience with judges and this kind of rule about victims. I have heard this rule for many years. Many judges impose this rule. I don't particularly agree with it. My opinion is you ought to let all the lawyers call anybody anything they want, short of a monster or the devil or, things that are really purposefully inflammatory. But if there's any evidence to show that they were a victim, prosecution probably should be allowed to call them victims. If there's any evidence to show that they might be rioters or looters, the defense should be able to call them a rioter or a looter, however they want. Those are just linguistic games. I don't think that the jury really cares about the linguistic games you got. If you make it a point to call them a rioter or a looter every time you talk about whatever one of their names is, you call them Rudy the rioter, every time, it's the jury may just think it's silly. They may think that's a ridiculous tactic, that it's up for debate. They're going to decide, what he is. But if you approach the issue in a genuine way and use the facts that you can prove as a lawyer to help inform the jury's decision, then they're going to go with you. It remains to be seen if these lawyers are any good at the advocacy part. We're going to see that coming up. But from what I have seen, the stage of the trial that they're in now is called the motion in limine phase. It's where both lawyers are trying to figure out what's the other lawyer going to do in this trial, and is there anything I can do to prevent them from doing it in order to gain an advantage, right? So this judge, according to the prosecution, these are the people who are trying to call the people who were shot victims, right? They're always going to try to call them a victim. They are the victim. They have, this prosecutor argued, for example, they have victim witness services. There's a Victim Protection Act. Victim is a term used to describe somebody who has been harmed in some way through criminal action. Well, the trial is the thing that determines whether or not that action was criminal. So in this case, the Rittenhouse case, there's an issue of self-defense. Was Kyle Rittenhouse acting in self-defense? We don't know yet, right? Kyle Rittenhouse is entitled to the presumption of innocence, as is every criminal defendant in this country. And that is where it stands as of right now. So the judge has a rule that says you can't call them victims until they've been proven to be victims. Now, that doesn't mean he's going to have to wait until the end of the trial, right? It means he's going to have to wait till closing argument, or he'll be able to say it in opening statement maybe, but not go over it with every witness. So the way this works out in reality is the prosecutor is just going to use their names, okay? He's not going to call them the victim. He's just going to say, the person that was shot. He may be able to call them complainant. I've heard that used. And I know when I got to Montgomery County a number of years ago, that was new to me coming out of law school, and I worked previously in Polk County where they just call everybody the victim, right? In Brazos County, I think we just called them the victim. Well, the defense bar in Montgomery County and Harris County is a little bit more aggressive, and so we demand that they be called a complainant. And so the prosecution has gone along with that. They're pretty much called the complainant. If that issue comes up, sometimes judges go the way of saying prosecutors can't call the victim a victim. And sometimes they say, or they make you say alleged victim or something like that. But again, these are just kind of like linguistic wars that I think the lawyers care about a lot more than the jurors are going to care about. Another way or area this comes up in is in a DWI case, you have a linguistic war about what to call the breath test machine. Is it a machine or is it an instrument? Well, the state wants to call it an instrument because they think that a jury is going to find an instrument more reliable than a machine because a machine can break down. I mean, again, I don't think that really matters so much. The jury wants to see what happened in this case. They want to see, is there credible evidence on your side? Are there credible witnesses on your side? Is there anything you can use to prove that the other side isn't doing things right? And the defendant is always going to have a huge advantage in these trials because they have the presumption of innocence. They have the burden of proof is always on the state. So the burden of proof is going to be beyond a reasonable doubt. So if there's any reasonable doubt that these actions were in self-defense, that there's something that was not proven, then it's going to be a not guilty verdict. We don't really have a system where you flip a coin and you say, well, yeah, I think this is probably, the guy's probably guilty. That means we vote guilty. It has to be proven beyond a reasonable doubt. And so I'm not surprised that a judge would have a rule that says, well, we're going to have a linguistic war. Well, I'm going to err in favor of the defense because the state has that burden of proof. They're going to need to prove it. If they can't prove it without calling the people who were shot with an AR-15 a victim, right? If they can't prove it unless they get to call them a victim, then they're probably not going to prove it anyway. It's not going to matter at the end of the day. And so I think obviously the media always is blowing things out of proportion. This has nothing to do with the outcome in this case, whether they get to call these people victims or not. They're going to call them plenty of things, and they're going to show what happened to them, and the prosecution will be able to play up, things like the style of weapon that was used, the amount of rounds that were used, whether or not the actions of the people involved were sufficient to raise deadly force on Mr. Rittenhouse's part. There's going to be plenty of room for argument. But this whole nonsense I'm seeing in the media about, well, the judge said they can't call them victims, but you can call them rioters. Well, that's because the judge probably doesn't have a rule about rioters and looters. This judge has probably had this rule about calling the victim a victim for 30 or 40 years. I mean, he probably practiced under a judge that did the same thing. And so I don't think there's any legal requirement to do that. If I was a judge, I would let you call, if the prosecution thinks they're a victim, call them a victim. If you think they're a rioter, defense, you can call them a rioter. But this is not a political ruling by the judge. This is more on the lines of lawyers like to do things the same way they've always done them. And this judge seems to have always done it this way. And so he's going to keep doing it this way. He's not going to change anything for this trial. So it's probably a positive overall that the judge is just going to stick to his same approach no matter what. I think that you do have a good argument. I like the prosecutor's argument that it was what's good for the goose is good for the gander. If I can't call them a victim, then they shouldn't be able to call them rioters. But you're just going to have to deal with that as a prosecutor. I know when I was a prosecutor, I would get adverse rulings from time to time, and you can't just sit there and whine about it. You need to move on.